In any felony sentencing, there are purposes and principles that are statutorily directed, which is to punish, to protect the public from future crime by the offender, and to promote effective rehabilitation that can be done reasonably. In determining how to achieve those goals, the court is required to consider the category of recidivism and the category of seriousness. Recidivism means the likelihood of someone offending in the future. To achieve a determination of whether you are likely or unlikely to reoffend, there's statutory guidance given to the court. I've considered those factors, and what indicates that you have a very high likelihood of reoffending is your criminal past, as well as your adjustment to any kind of penalty, your history of disregard for others, your history of non-appearance in court, non-compliance on sanctions, and fleeing from any sort of justice. I did review a pre-sentence report that was prepared at the direction of another judge formerly of this court when you were sentenced for the last time that you went to prison, which was on 5 separate felony cases. Those cases included case number 622007, which was a felony possession of drugs and attempted conveyance of drugs, 623559, which was a failure to comply with the order or signal of a police officer, a felony of the 3rd degree, and a felony of the 4th degree of receiving stolen property of a motor vehicle that had been stolen at gunpoint in Cleveland Heights. Case number 623956 was a domestic violence, a felony of the 4th degree, also aggravated menacing. You ultimately served time on all these cases, but I'll note that the domestic violence carried a mandatory sentence because the victim, who was your girlfriend, was pregnant, and the law requires a mandatory term. In case number 626442, you pled guilty to attempted robbery as amended for a robbery that, according to the pre-sentence report, included firearms of a barbershop. In case number 632515, you pled guilty to a felony of the 3rd degree of having a weapon while under a disability, also possessing crack. You had an active felony warrant at the time. According to this pre-sentence report covering those 5 cases, the date of which of preparation was July 18th of 2019. At that time, you were well known to law enforcement, including Cleveland Police Department, the Ohio Department of Public Safety, and Euclid. You were known to be a member of the Lakeshore Boys Gang or Lakeshore 6 Boys Gang. You were known to flee apprehension by law enforcement, as a historical note in the pre-sentence report. As of July 18th of 2019, you were the father of 5, who today would be ranging in age from 6 to 18. It further revealed that you were shot in 2012. At the time of the preparation of this report, there were outstanding warrants for you out of Wycliffe for drug offenses. You have multiple driving license suspensions, and I'll note that at the time of the offense involving Amir, you didn't have a driver's license. Your driving privileges had been suspended at least 25 times as of the date of the 2019 pre-sentence investigation. You indicated in that report being a heavy alcohol user from the age of 15, a heavy pot user, referring to daily for each of these, from a younger age than that, I believe 12. As of the age of 15, a daily ecstasy user. As of the age of 20, a daily K2 user. As of the age of 23, a daily opiate user. And as of the age of 25, a heroin and crack user daily. Are you now 33 years old? I heard the state say your record goes back to, I believe your record goes back 20 years. I'll get to that in a moment. So this indicates a history, and as referred to earlier by the state, a history that includes similar charges to what you are being sentenced for today. Back to the recidivism issue. Having a criminal history is a likelihood of reoffending. Having an adult or juvenile criminal history so indicates. Not complying on probation is another indicator. Having a substance use issue that is unaddressed is another issue. Expressing remorse is to be considered when it comes to recidivism. I heard you say you didn't know what you were doing. You knew you left. That's the crime here. And you made it very clear. You left because of fear of repercussions and consequences by law enforcement or a court system. I did consider your criminal history, and it is extensive. I'm going to place it on the record because it is a factor I must consider in determining whether you are likely or unlikely to reoffend. At the age of 13, 2004, you were found delinquent of attempted grand theft of a motor vehicle. You were placed on community control. That was December of 2004. May of 2007, you were adjudicated delinquent of attempted receiving stolen property. August of 2007, you were placed on probation in juvenile court for attempted possession of criminal tools and criminal damaging, violated that supervision twice. You were found delinquent of aggravated rioting in 2007, December 2007. March of 2008 in juvenile court, there was a matter that was bound over that was felonious assault and robbery. In juvenile court in 2008, you were adjudicated delinquent of drug possession. In 2009, in juvenile court, you were adjudicated delinquent of robbery. There was a suspended Ohio Department of Youth Services commitment. You were placed on probation. You violated at least one time. You appeared in court over the period of about a year and a half on that matter. You were adjudicated delinquent of theft in 2009 in juvenile court. That was September. October of 2009, charged in the juvenile court of kidnapping and robbery was transferred to the General Division of Cuyahoga County Common Police Court. In 2009 in Common Police Court, you pled guilty to robbery. You were placed on community control sanctions. You violated twice. In 2010 in Stowe Municipal Court, you were convicted of obstructing official business. There were warrants issued for you twice. In 2011 in Cuyahoga County, you were convicted of attempted robbery. A warrant was issued about a month after your change of plea. You were ultimately apprehended and sentenced to the Cuyahoga County Jail for a period of 6 months. August 2011, Stowe Municipal Court, drug possession and obstructing official business. You were convicted. There were warrants issued for non-appearance. Those warrants were recalled in 2014. In November of 2012, you pled guilty to attempted robbery. You received 17 months at Lorraine Correctional. In 2017, Euclid Municipal Court, you were convicted of drug abuse. In October 2017, a case out of Euclid in Cuyahoga County Common Police Court, you pled guilty to drug possession and received a 10-month sentence at Lorraine Correctional. In 2017, that would be November, a case out of Lyndhurst. You pled guilty to failure to comply with the order or signal of a police officer, a crime you're here for today, and received a 15-month period of incarceration at Lorraine Correctional. December 20th, 2017, you pled guilty to domestic violence, a crime that you are being sentenced for today with the attempt statute, received a mandatory period of incarceration of 6 months. In February of 2018, you pled guilty to attempted robbery and received a 15-month term at Lorraine Correctional. In November of 2018, you pled guilty to a weapon under disability and received a 9-month term of incarceration at Lorraine Correctional. Anyone who goes to prison generates an institutional summary report. I reviewed yours. There's over 40 write-ups. Many of them are just for refusing to do what you're expected to do, ordered to do, signed up to do, as well as bringing contraband in, organizing for contraband to get brought in, that being drugs, through balloons and other means. When there were shakedowns of your cell, there was contraband found. I would consider this adjustment to be negative, meaning not good. Today we're here to address those purposes of felony sentencing that I mentioned before: punishing, protecting the public from future crime by youth, and promoting effective rehabilitation. I have reviewed the same seriousness factors that I heard referred to by both the state of Ohio and your attorney. And after considering those factors that indicate your conduct is more serious, and listening to everyone who I heard today, and considering 2921.12b, I find that your argument is not persuasive, Mr. Jordan, and in fact this crime is extremely serious. When it comes to considering factors that would indicate whether you're more or less likely to reoffend. As I just explained by the record, the clear pattern that has been established over 20 years, and your desire to put you first. You are dangerous in our community. You are dangerous. It just is inhumane, especially as a father of 5 kids as of 2019, that you hit a little kid who's out being a little kid playing, and you leave because you're concerned about the consequences that you have, because once again, you're offending our community with an outstanding warrant. So you do what you always do. You took off. And then you continue to do that as law enforcement looked for you and found you cowering in a storage unit. The crime was that you left. This is humanity versus depravity. Your sister who wrote the letter believes that with proper support you can continue making positive changes in life and stay on the path of healing and growth. I haven't seen those changes, and I haven't seen anything to indicate that path. Those are the findings with respect to recidivism, with respect to seriousness. If you wanted to turn yourself in, you know how you can do it? Go to a police station. It's not about miles per hour. By the way, driving once again without a license, no respect for even taking to the roadways. For years. This is not about what Amir was doing. This is about that you left, which is what you did, your fear of consequences. In case number 695-281, that is the failure to comply. I'm imposing a 3-year term at Lillian Correctional. That is the maximum term. In case number 695-144, also a felony 3 that carries the same penalty, I'm imposing a 3-year term. By law, those sentences must run consecutive. As I mentioned earlier, that is a requirement with the felony 3 of failure to comply because of the seriousness it poses to everyone in your path. Considering what your sister had to say, in case, it's consecutive 3-year terms in 695-281 and 695-144. In 695-091, upon completion of your 6-year term, you will be transferred to the county jail to await placement in a community-based correctional facility. That's the case that carries 6 to 12 months. You're required to complete the entire CBCF program, which is a lockdown facility, in the hopes that you can gain some tools before you regain any kind of liberty and join our society, hopefully as a productive member who doesn't go out and hurt people or just put yourself first. You do face possible post-release control supervision for a period of up to 2 years. Costs of these prosecutions are assessed. Please be advised that you will receive credit for time served. The sheriff will calculate, but my understanding is that it's 218 days. Your license is suspended in case number 695-281 for life. In 695-144, it is suspended for 5 years. Is there anything further on behalf of the state of Ohio? May I see Council Synenberg first? Thank you. Sidebar, your attorney requesting that you be appointed appellate counsel. that will be done. Thank you. If there is nothing further, we are in recess. Anything from the state?
No, nothing.
Anything, Mr. Jordan? Your attorney also requested that you be found indigent and the cost be suspended. I'll permit you to perform community work service in the penitentiary to satisfy costs. There being nothing further, again, with deepest condolences to those of you heard here and with great appreciation for your patience. It's a sad day indeed. I'm so sorry for your loss. God bless you. We are in recess. Thank you. Your remand.